In 1971, a man named Gerald Mayo walked into the United States District Court for the Western District of Pennsylvania and filed a civil lawsuit against Satan. Not a company named Satan, not a person named Satan, Satan, the actual devil, Prince of Darkness, Father of Lies, the one with the horns. The case was formally titled Gerald Mayo versus Satan and his Staff, and the judge had to take it seriously. Gerald Mayo was a federal prisoner at the time, which explains certain things. Federal prisoners are entitled to file lawsuits, and they do so in remarkable volumes. Courts receive thousands of pro se filings every year from inmates with a great deal of time on their hands and a growing familiarity with the legal system. Most of these cases are dismissed quickly. Some are not. Gerald Mayo's complaint alleged that Satan had, on numerous occasions, directly caused Mayo substantial suffering and had deliberately placed obstacles in his path, all in deliberate violation of Mayo's constitutional rights. He was seeking damages. He was requesting that the court issue an injunction against Satan continuing these activities. He was, legally speaking, doing everything correctly.
This is what makes the case genuinely wonderful, rather than simply sad. Mayo had done his homework. He understood the basic structure of a civil complaint. He had identified a defendant, articulated a harm, and requested a remedy. The paperwork was in order. The filing fee had been paid. Federal District Judge Gerald Weber received the complaint and faced a genuinely novel legal problem. The case could not simply be dismissed on the grounds that Satan does not exist. That would require the court to make a theological determination, which is very firmly not the business of the United States federal court system. Courts do not rule on the existence of supernatural entities. That is not what courts are for. So Judge Weber had to find another reason. He published an opinion, a real documented, archived legal opinion that runs through the problems with Mayo v. Satan methodically and with what appears to be a barely suppressed sense of amusement. The first problem the judge identified was service of process. In order to proceed with a lawsuit, you have to serve the defendant. You have to formally notify them that they are being sued and give them an opportunity to respond. This is a fundamental requirement of due process. Without it, you cannot proceed. The court was not aware of Satan's current address. This is, on reflection, a significant obstacle. The judge noted that even if an address could be established, there was the additional complication that Satan appeared to reside outside the jurisdiction of the Western District of Pennsylvania. International service of process is complicated enough when the defendant is in, say, Germany or Japan. Extraterritorial service into a theological dimension raised procedural questions the court was not equipped to answer.
The second problem was the class action question. Mayo had sued Satan and his staff, which implied multiple defendants. Normally, when a plaintiff seeks to sue on behalf of a class, meaning they are not just seeking damages for themselves, but representing a broader group of similarly harmed individuals, they must demonstrate that the class is identifiable and that the plaintiff is an adequate representative. Judge Weber noted that it was unclear whether Mayo was suing on behalf of all humans who had suffered at Satan's hands, which would potentially constitute the largest class action in legal history, or only on his own behalf. The complaint was ambiguous on this point. If it was a class action, the certification requirements had not been met. The third problem was causation. Mayo alleged that Satan had caused his various misfortunes. Establishing that any specific harm was directly attributable to satanic intervention rather than, say, ordinary bad luck or Mayo's own choices would require a standard of proof the court was not prepared to define. And finally, the judge observed, even if all these procedural obstacles were somehow cleared, the court had serious doubts about its ability to enforce any judgment or injunction it might issue. Contempt of court orders are meaningless against an entity that has, by Mayo's own description, been operating outside divine and human law since before recorded history. What exactly would enforcement look like? On all of these grounds, the court dismissed the complaint without prejudice, which is the legal way of saying, we are not ruling on the merits, We are just saying this particular filing has problems that need to be addressed before we can proceed. Without prejudice is important. It means Mayo could, in theory, refile, if he could sort out the address issue, and the jurisdiction question, and the class action certification, and the enforcement mechanism. The case appears not to have been refiled. What makes Mayo v. Satan a minor classic of legal history is not that it happened. Federal courts receive bizarre filings constantly, but that Judge Weber took it seriously enough to write a proper opinion. He could have dismissed it in one line. Instead, he engaged with the procedural questions genuinely and produced a document that law students have been reading ever since, partly as a lesson in civil procedure and partly because it is one of the most quietly entertaining judicial opinions ever written. The full opinion is a few pages long. It is dry. It is methodical. It is written in the precise, neutral language of the law. And somewhere in that neutral language is a federal judge sitting in Pittsburgh in 1971, carefully explaining to the record why the United States District Court cannot currently process a lawsuit against the Prince of Darkness. The law, it turns out, has an answer for almost everything, even this.